Townsend on behalf of the people.
And good morning, Your Honor. But please, this honorable court, Brandon Bird, PA 3734, on behalf of Stevie Brooks, who stands to my right.
Name, sir?
Stevie Brooks.
All right. And you're requesting an adjournment?
Yes, Your Honor.
Oh, you were assigned on March 10th. All right.
And Your Honor, if I could address bond when appropriate as well.
All right. Probable cause conference will be adjourned to March 27th, 2025, 9 a.m. or as your invite indicates, yes, Esteban.
Your Honor, on 310, the defendant called his mother, and in this call, the defendant says, do you have the girl's new number? And she says, whose? He says, the girl. She says, nah, she got a new number. He says, she hasn't called you from the 262 number. And she says, probably so what's up. He says, you need to give her a call. I'll be doing 10 to 20 years. He says, they set up 10 years. That's what one of them said. He said, I'm just saying they're talking to her. He says, you could say something to her. So I'm concerned he's having third parties reach out to the victim on this case through his jail calls.
Any response?
Yes, respectfully, Your Honor. I had a thorough discussion with my client yesterday, and especially about having no contact with the complaining witness. And he understands that he has to have no contact with the complaining witness. He doesn't want to be in jail. Actually, we were going to ask to lower his bond to a personal bond so he could be released. He's 45 years old, lifelong resident, Your Honor, has a stable job in which he's risking losing everything if he's in jail. He doesn't mind wearing the tether or abiding by any other conditions. I understand this isn't a good look for him to abide by conditions due to the fact that he made that phone call, but that phone call wasn't threatening in nature. And he reached out because he was scared. He was forthcoming with me about that phone call, actually, when I had a discussion with him. So respectfully, Your Honor, I do understand that was a violation of probably one of his bond conditions, no contact through a third party. But after discussing the matter with my client, he's going to lose everything if he's here. He understands if he does anything of that nature, he's going to be right back in jail. He's going to be right back in jail if this court were to allow him to get out today. He has a litter of puppies that's not being taken care of, two dogs that need his attention. If he can't go back to the place of the location, Your Honor, he can live with his mother at an alternate location. So respectfully, Your Honor, I do understand we had this phone call in front of us and it may be damaging, but I told him about it. But respectfully, Your Honor, we're going to ask this court no contact for a no contact condition. If this court wants to put a tether on my client, he has no problem with wearing the tether. He has no problem with going to an alternate location. That's what we're going to be asking for.
Your Honor, I would object to any change in his bond. He has numerous dismissed CDs. I believe he also has a hold out of Lapeer for a violation of probation and a hold out of Dearborn for an OWI. In this case, in the report, there are 5 incidents of domestic violence, and one of those is a strangulation of the victim reported to officers. So I have extreme concerns, especially with him trying to reach out to third parties, that he would be able to abide by court orders.
The defense motion for a bond reduction is denied. Bond will continue. With reference to the phone privileges that the defendant has, it's clear that he violated those provisions. He can't. It's made clear to him. No contact either directly or through third parties during the time of his arraignment. So at this time, the court will also revoke defendant's phone privileges entirely.
Thank you, Your Honor.
Court calls.
Asli Bashir, with and on behalf of Mr. Calvin Koopa, Mr. Bubis and Singman.
Calvin Koopa.
We would like to set for preliminary exam in this matter.
All discovery is complete.
To our knowledge.
People have their witnesses available the 25th. Preliminary examination in person, March 25th, 2025, 9 a.m. That is before me. Bond will continue. Thank you.
Oh, okay, sorry. Could we address bond in this matter? I apologize.
Briefly.
Thank you. Mr. Koopa has an elderly mother who lives at the address that he has as his mailing address with the court, who needs constant care, and he would like to return home to assist with her care. He is willing to go on tether and to follow any conditions the court believes might be appropriate to show that he is not a flight risk. Mr. Fuqua also has some health conditions that he would like to be able to address out of custody while he's addressing this case.
Response from the people.
The people would object to any modification to the bonds. The fact that are alleged here is that this individual was intoxicated. He was being investigated for public intoxication and was found with a loaded .380 Ruger handgun in his left front pocket. There was also suspected crack cocaine found, although that has not been sent to the lab. At this point, people are concerned for the safety of the public.
Anything else?
I would just like the court to consider that this is, offense from several years ago, and I do believe that Mr. Fuqua, his behavior may have changed in the interim, at least.
Motion for bond reduction is denied. Bond will. Thank you.
Assistant Public Defender on behalf of Mr. Scott. Yesterday we submitted some competency orders. It's been referred in the matters that are already pending in circuit court as well.
Or no, 60 it should be, but. All right. Forensic evaluation is ordered. I've signed the orders.
Thank you.
Set a competency hearing for May 15th, 2025, 9 a.m.
Thank you, Your Honor. Your Honor, if I could be heard on bond.
Yes, briefly.
Your Honor, Mr. Scott is here. As the court's well aware, he's a longtime resident of Ypsilanti. He's not a flight risk in any way. This matter is charged out of a store over in Ypsi as well. If the court he is being held in the circuit court cases on $25,000 each. If those, we'd ask for a personal bond in the event he's able to bond out in those matters with house arrest, tether, and a no-go to the location of the alleged offense. We'd also ask that. He would also, certainly drug testing and any other screening as appropriate in terms of community corrections, outpatient treatment programs.
So here's the thing. So that you know, yesterday, I think, was it his mother? They were trying to hand some documents to me yesterday. I told them I couldn't accept them in that fashion. And so I told them that they may want to contact you, Mr. Gay. My further understanding is I believe that Mr. Scott, I was informed, and I'm not sure of this, has a guardian.
My grandma.
Hold on. And so I'm not sure how that would play into any contemplation of a release on this. So at this point, what I'm going to do, and I don't need a response from the people, is I'm going to deny the request. Something has to be put together for me. I'll hear the motion, but I'd have to see a much clearer picture of exactly what's going on with this.
Thank you, Judge. And if we, it's kind of, there's two courts, and so if we can get clear on the other one.
Who's the other?
I think it's Judge Slay, Judge.
Judge Slay.
Yes. And Judge Barr. He's actually got a 10,000 with Judge Barr as well.
With the paraphernalia thing, I don't know,
What?
paraphernalia or something
Where?
for the $10,000 bond. I
There's a
guess?
paraphernalia.
See?
Yeah.
Okay, that's before Judge Barr, so
Yeah.
you'll have to deal with that.
Okay.
Okay? All
Thank
right.
you, Judge. And my apologies. I didn't catch the competency hearing date.
May 15th.
Thank you, Judge.
All right. Court calls the case People versus London Daughtery.